Ladies and gentlemen, we start right away with the first panel, with the first of our three panels. Its goal is to set the scene, as it is called in the agenda for the Justice Without Litigation project. And the basic question is how to better consider non-contentious justice in EU law and in justice policy instruments. I therefore would like to introduce to you the participants in this panel. Lukas Mandl from Austria is a member of the Parliament and of the LIBE Committee of the Parliament, the Committees of Civil Liberty, Justice and Home Affairs. Petra Pejchová, she represents the Czech Ministry of Justice in her function as JHA Counsellor, competent for civil law matters at the Czech Permanent Representation to the European Union here in Brussels. Salla Saastamoinen, Director of Civil Justice at the EU Commission, and Professor Karl Stöger from the University of Vienna. He's one of the authors of the legal report. Please come up and grab a seat, if it's all right. Can you tell us about the main general goals of judicial cooperation in civil matters and how the non-contentious side of justice fits into these goals?
No, thank you. Can I say, Paul, for the question, and good afternoon to the whole audience. And I start indeed congratulating for this project group for the great project. If I look that in a little bit general, indeed, on our policy goals, we are talking here about justice without litigation. And what it brings to my mind are two things. One is the efficiency of the justice. That's a little bit that without litigation, somehow we find it would be more efficient. And justice, on the other hand, it has to be seen in the framework of the European values and rights and those of the rule of law principles. So that way, from these perspectives, one can look at it. From the rule of law principles, I think that you will hear more this afternoon in a panel. So the Commission has been doing an annual rule of law report, I think now for 4 years, and this year we have even included some recommendations to the member states. And we look judiciary, or the judiciary and the independence of judiciary is one main part of that rule of law report. And actually those principles they would need to be respected in any justice, even without litigation. As regards the efficiency aspect and effective aspect, there I would refer to the Justice Scoreboard. It was mentioned here already by President Michael Umfare. So there we will try to look indeed to the ways that the member states have organized their judicial systems, different elements, and it's not so to compare to each other, but to see the trends in the member states. And there we have done 10 justice scoreboards so far. And for example, on the pandemic time, we saw that, let's say, 10 member states was improving efficiency. In 10 member states, there was a little bit decrease. So similar environment actually can lead then to the different results in the member states. But when we still continuing, when we think about this efficiency and effectiveness side, we have some other elements that are very much now trending and our policies and our policy goals, and one of them being then digitalization of justice. So this is one means how we can reach the citizens everywhere and make the functioning of the justice more efficient. We have proposed the digitalization of all the procedures of the cross-border judicial cooperation. So we are bringing this principle into practice by the legislation. And then we have also supported the member states financially in their recovery and resilience plans, and there we know from examples that the member states are actually using it also in this area of the justice. When I come even then closer, naturally then one aspect of the efficiency is considering that can we solve possible disputes without litigation. And as your project has shown, that is possible. You have presented in this area in the Central European model where the notaries act as a court commissioners. We have noticed, and that was specifically in the area of the successions. We have noticed a similar trend in other areas or in the area of family law. For example, the non-contentious divorces have been subject of the development in many member states. And naturally, we have to react then in the European level. Our judicial cooperation is based on the mutual trust and mutual recognition. And that means that if we have then the outcome of the case, non-contentious case without litigation, which would need to circulate in Europe, we have to find the ways that it is recognized in other member states. And it happens indeed when we last negotiated our Brussels 2 bis regulation, that aspect was taken into account and specifically added, successions and other areas, but we do have a list of other union instruments where we will need to look the same question with the next reviews. So in that sense, what is being done in this project will have reflections in our European instruments for the future. And I will finish. I'm finishing with one remark and what I was specifically glad for this this project, that I understood that it might have then impacts to certain countries that were participating. So showing a good example with between your six countries might actually lead to this kind of non-contentious dealing of the cases through a notaries as court commissioners on further countries, and that's a major effect in a project that we have been funding. So that's why I'm happy that we have been able to use our tool of the justice program actually then of bringing forward this trend of more efficient justice in dealing the cases without litigation.
Mrs. Saastamoinen just mentioned the rule of law and talked about the rule of law. What would you say, the non-contentious proceedings, how can they strengthen the rule of law by making access easier for citizens?
Absolutely. I would say, first of all, thank you for having me. Thanks for the project. Thanks for this important contribution to rule of law. And this is what it is. I want to put it in a larger framework. Even today, we see on the other sides of the Atlantics that there is some public sense still in our societies of the West, of the free world, for the meaning of rule of law, and that it has to be strengthened. It's not just given, it's something we have to develop and something we have to work on. That's why I highly appreciate that the Commission has started the rule of law reports annually. I have served as the rapporteur of the largest group in the European Parliament, shadow rapporteur of EPP, on negotiating on these reports from the Parliament side, and I want that we as a European Parliament continue to contribute to the Commission's reports on the rule of law because it has to be developed. And I also want to share with you why to put it in a larger framework, because this might be the parliamentary approach to the whole issue. Today in the morning I had the privilege to meet with representatives from North Macedonia in the Parliament. And we tend as European institutions to ask future member states to strengthen rule of law. But we must not forget about the fact that we have to do a lot for rule of law within today's European Union countries. That's also why not only the annual report of the Commission, the Parliament contributes to it, is important, but also the mechanism to strengthen the rule of law. And I always want to emphasize that we do it not on behalf of some centralized EU body. We do it on behalf of the citizens of these very countries, where rule of law might be under pressure or might not be fully given and in proper place. And this is why it's important to understand rule of law, and also to understand that a lack of rule of law is not just any crime like a bank robbery, and the bank robbery is a bad thing. I don't want to be misunderstood, but a lack of rule of law means to undermine confidence within a society. That means lack of trust between the one neighbor and the other neighbor in the same street maybe. So this is something we have to avoid in Europe. This is something that strengthens Europe if we have rule of law in proper place. And to develop rule of law, and here it comes to the issue of today's event, of this very appreciable project. To strengthen rule of law also means that notaries are not just some added value, but notaries are a core part of rule of law in proper place. So if you want rule of law and if you talk about rule of law, you also have to strengthen notaries and to put them in proper place. And this is my understanding of what we talk about, and also my understanding for future development and future negotiations on the rule of law reports ahead in the coming up years.
You mentioned the proper place, as you said. Should non-contentious proceedings be more reflected in EU justice policy instruments, do you think?
Absolutely. We need systems in place that are understood by the people that are served by these systems, and these are the citizens, the people of our countries. They are in need, often in very specific and exceptional times in their lives. It's not only about business; it's also about private life for many people. It's about life and death, literally, in many cases, and this is why this kind of professional assistance is so important.
Mrs. Pejchová, Lukas Mandl just mentioned matters of life and death. What is the experience with the court commissioner systems in your country? Can you tell us a little bit about that, and how did it strengthen, or does it strengthen the rule of law?
Thank you very much, and first of all, thank you very much for the invitation. It's a great honor to be here, and I am quite impressed with the results. The book has more than 200 pages. Sorry, 200, not 20. It would be too voluminous. But this shows that there is a lot to say about this topic. And it's also something the Czech Republic is familiar with, because we are one of the countries in which notaries act as court commissioners. I read in a description of one of the panel, or in the invitation to this event, that this is a particularity. This is indeed a particularity, but at the same time, I believe that it's an example of a well-established system, a well-established practice, and we believe that the system, which as is now in place in the Czech Republic and elsewhere, is working very well. And it has quite a history and a tradition now, I would say. So we already, and I had already a brief exchange before this event started with our Slovenian colleague, and she mentioned that they are already working on perhaps putting a similar system in place in Slovenia, as
we'll talk about that
have.
Later,
yes, yeah. And and we were also talking about it. We would perhaps introduce their system in our national system. So this exchange of best practices, of information, is really important, and that's the greatest added value of this project, I would say. Going back to your question. The system is very well functioning. For instance, also for the purposes of the European Succession Regulation, notaries are perceived as courts. So this shows that the role of notaries is quite important in the Czech Republic in the system, and it's quite well embedded in the whole system. We have to look at it as a system, not because notaries have to cooperate with other legal professionals, with the clients, with also other notaries across Europe. So I was very pleased to learn that they are trying to now put a similar, perhaps you will also talk about this later, but there will be a system for a digital exchange of information about Central European notaries, and this is also something which I consider very important, and this is also something that shows that this is a great respect for rule of law, for exchange of information, and for ensuring that everyone has an exchange and access to justice as he or she deserves in this whole procedure.
A little bit back to the scientific level, Mr. Stöger. The system works. Mrs. Pejchová just said, if notaries take over non-contentious judicial tasks, does this meet the requirements of the rule of law, in your opinion?
Well, I think it does, and it has to. I mean, first of all, the system works. The system works in all the states which participated in our project, with the exception of Slovenia, where talks are ongoing. I mean, the main thing is if notaries and courts act in the area of non-contentious proceedings, they have to meet the guarantees of Article 6 of the European Convention on Human Rights. We all know that according to the case law of the European Court on Human Rights, let me mention the Mandl and Norway case, Article 6 is only partially applicable to non-contentious proceedings, as Article 6 requires a dispute. And there can be some cases in non-contentious proceedings where there is no dispute, where there is a unilateral procedure. But that shouldn't make a difference. Of course, we can go further than the minimum, and I think what we have to expect, if we talk about the rule of law, is that Article 6 is fully applicable throughout non-contentious proceedings. And Article 6 is not only mirrored, but even extended by Article 47 of the European Charter of Fundamental Rights. And I think this should be the baseline that should be met by all non-contentious proceedings, irrespective of the case law, which is of course correct, but still, I mean, I think it's quite obvious that we should go this step further. And as we're doing in the project, it's quite clear if notaries act in supporting courts or even in taking over functions of courts, they must meet the same guarantees. And I mean, Article 6 and Article 47 are a baseline which is somehow easy to identify and which has got some core guarantees, namely independence, freedom from instruction, and very important, impartiality. And this is what the rule of law requires. And I think this is what has to be met. And the good news from my point of view is in the member states participating in this project, these guarantees are met by the national system, as was confirmed by our national rapporteurs.
What would you say, what is the difference when tasks are transferred from courts to notaries or to other legal professionals? Is there something that notaries do better or offer more in that field?
Well, I think there is one thing that notaries should offer, and which they also have to offer to justify their specific role, which is already in place. So there must already be some difference, otherwise we wouldn't have a court commissioner system. And that's the last point I mentioned before. This specific obligation of impartiality towards all parties in the procedure, including those they are advising. They might even be advising unilaterally, but they are still obliged to be neutral. All the more if they take over the role of a court and try to bring several parties together. That requires very strict requirements of impartiality. And in a way, it does not make sense for every legal profession to act impartial in this respect, because in some cases you need someone who's not impartial, but who's standing behind you all the way. But that's a different role. And if notaries act as court commissioners, they have to be impartial, and that is something that is enshrined in the professional statutes of the notaries, not only in the states which participated in the project, but beyond that. And I think that's the important thing. And that is also something to take up the idea that could be monitored in the annual rule of law report. If notaries are assisting courts, do they meet these requirements? And we will see that they do, because that's already enshrined at the national level. So I think it's not a coincidence that this specific role of notaries was already recognized by the European Court of Justice, for example, in the Piringer case. And the second thing is, I don't think that it's a coincidence either that this particular role of notaries alone already exists in many member states, and that's what makes the difference. It's a different description of their role in the process.
Mrs. Pejchová, one last question. Do you think that they also think that the non-contentious side should be more reflected in EU justice policy instruments, like just mentioned?
Yeah, I would say so. definitely we will now have the tools in place, meaning I would pick up on where Salla left off on digitalization, because that's one of the priorities of the Czech presidency in the Council, and currently we are negotiating a legislative package which would further boost and enhance cross-border judicial cooperation, not only between or among judicial authorities, but also among citizens and judicial authorities. And this could further help to again ensure just access to justice, and this is also something which will include some aspects as cross-border, or there will be provisions covering effects of electronic documents, for instance, on electronic seals and signatures. And there are also some other pieces of legislation currently being negotiated, for instance, or identification of users. Those are all tools which we can use to further boost the cross-border judicial cooperation in instruments, currently existing instruments, and when the time is ready to reopen those instruments to assess their operation, their functioning, we can also make advantage of those existing, for instance, digitalization tools and other instruments which we will have at our disposal at that time. So the answer is yes.
Yeah. Mrs. Saastamoinen, you just heard what she said. Did the European Commission hear it?
Yes, we have heard it, and actually I'm building up indeed. Thank you, Petra, on this digitalization, and actually commending the notaries because we have brought the digitalization through the company law for establishing companies to the member states, and that required the possibility to fully digitally way register and establish a company, and all these practical aspects that you need then the digital identification, signatures, notaries have been in the forefront of taking them up. So that means that notaries are actually then ready to use them in all kind of cases. So, and we will continue this. We will come up with a even new proposal of upgrading the company law on the digitalization next year. So that is one aspect that we are then bringing forward. And the second aspect is this, indeed, the aspect of the recognition, so that the notarial acts, authentic acts, that we will be sure that they are then circulating and that they are being recognized under our instruments. So this is something that we will look in the future revisions. Might not be the most well, that way it's most important because that covers everything else, which is not elsewhere, is the Brussels I review that will be on the table of the next Commission. We are starting the evaluations, and all these studies that we take, we are actually then collecting and looking how we can best look, or how we can best then include it in the work of the revisions. So I would say in many aspects from the increasing efficiency, yes, we will bring it forward. But I can just indeed echo once again that naturally the procedures have to be such that they are respecting the rule of law. So it has been very important also in the project that this is actually now somehow proven. That will be easier then for the Commission to convince all the member states that they have to accept these, because we have even scientific studies to say that yes, they fulfill these principles. Thank you.
The promises of Mrs. Saastamoinen end the first panel. Thank you for the participants. Thank you.